Let's continue with our moot court proposition discussion. So I'll just pick it up from where we left off. So next para is, as a reaction to these developments, a radical militant group oppressed fight back was formed. Now the this para, as a reaction to these developments, in fact that is also a very open-ended phrase, and opportune persons should be able to use it in their favor, be it a plaintiff or a respondent. It doesn't actually mean anything, just these developments. So you can actually say, the applicant say that okay, because of you this militant group was formed, because these whatever has occurred above this paragraph. So nobody can actually know whose fault or whose liability it is that this militant group was formed. The applicant can argue that okay, it is because of you that they were formed, and respondent can say it is because of you that they were formed. So therefore it is open-ended and therefore marked as yellow by me. This phrase, obviously a radical militant group OBF was formed. So the phrase radical militant group is in favor of the applicant, and the rest of the para that is marked as red is obviously in favor of the respondent, and then you may please read it on your own, right? However, I'll just tell you one small tip, that is, whenever they're talking about life of honor and dignity, so you must focus not on the issue of radical militant group or that the killings that they are doing. Always try to focus on the life of honor and dignity, right, whenever you are arguing from the side of respondent, because this speaks to the right of self-determination that is recognized by international law. And actually it is illustrative, or a parallel can be drawn by Bangladesh, because as I said that there are certain references to the India-Pakistan position as well, and this radical militant group OFB is actually comparative with the Mukti Bahini force that the Banglas created when they wanted to separate from Pakistan and form Bangladesh in 1971. So it would be prudent for any law student who is preparing for this moot court to actually read up about right of self-determination and actually give an example of Bangladesh, because Bangladesh, even though people were opposing that at the time of formation, but obviously right now it is an internationally recognized nation by all the developed nations, be it Russia, China, or USA. Every single country in the world duly recognizes Bangladesh, and Bangladesh was built by the forces just like the OFB. So therefore OFB cannot be termed as immoral or illegal or doing anything wrong, right? So this you can say. Next, on 12/3 so and so OFB executed a series of so and so bombs. Obviously this whole para is in favor of the applicant because it speaks to how many killings have they done. However, you must focus upon this if you are a respondent, and since it says bombings were given in military cant areas, right? So therefore what the respondent can argue is that actually these bomb blasts and whoever died, it was done strategically in military area so as to not harm the civilians. The intention was to fight the enemy and not the bystander, the innocent, and whoever have been killed like 120 civilians, they are just casualties of war. Unfortunate, but yes, casualties of war, and these things have been happening since the time immemorial. In every war, nobody can ensure that only the enemies will die and the civilians won't, and we can only try to prevent such actions, and therefore we were well intended, we never wanted to kill any civilian, therefore we bombarded only military areas intentionally. So that is the counter that you can say. Next, Katha went under regime change and so and so, so and so, so and so, so I mean all these lines are in favor of the applicant because it only speaks to the supposed autocratic nature of the Mikhail, and it says he was an autocrat and a disbeliever in the idea of constitution. So obviously this will be heavily used by the applicant in its favor, saying that this president or PM was so and so, so and so. However, there is a counter to that. What you can say that it only says what he believed. that he was a disbeliever in the idea of consultation, but that only speaks to the his ideology and not his action, right? As every one of us know, when elections are happening, people act differently, and in power they act differently. So you can state that this only speaks to his ideology, but any nation or any leader or any person is not just based upon his ideology but on his actions, right? And in our opinion, Mr. Mikhail did no wrong. I mean, obviously, you can argue that, right? Now, this line is obviously in favor of the respondent, that the rise of Mr. Mikhail coincided with the anti-supplicant sentiments among the Kathans because of the discrimination faced by the ethnic Kathians, right? So therefore, Mr. Mikhail was not alone. In fact, whatever he thought was justified, because whatever the ethnic Kathians face in Seplica. Obviously, this is also a practical life example, that is the Hindus in Pakistan, because as you know, practically speaking, Pakistan has been killing Hindus in its own country, and the population has fallen from I mean 10-20% to less than 1%, right? So you can give an example of that. Obviously, this whole paragraph, what is marked in blue, is in favor of the applicant, and I will not dwell into it because it is actually self-evident. Next, Mr. Jenks started building defense alliances with two other bordering nations having a history of political and armed conflicts with Kartha, and this is one of the most important lines or paragraphs in the whole moot court proposition, because this is the basis on which the Kartha had initiated this war, because you can say the very action of Seplica entering into alliance with my enemy countries, or the countries who are always speaking in against of me, this was the first step towards act of war. It can be argued that war in today's circumstances it does not begin with bombing or killing of people. The wars in today's scenario actually start by alliances. So therefore, the very beginning of this alliance was a declaration of war, and we were not the first one to actually initiate it. Whatever we did was in self-defense, and it was a preemptive defense step at the worst, right? So please do read up upon preemptive defense, and then you'll know more about this. Obviously, whenever you read this, always try to read about the Russian-Ukraine war and the involvement of NATO in it, because this is obviously a comparative analysis of this, and they have drawn their inspiration from the Russian-Ukraine war and the role of the NATO in it, right? So please do read upon that. Also, if you're the applicant, read Europe's or Ukraine's legal arguments against Russia, and that will help you as an applicant. And if you're the respondent, read Russia's political and legal submissions given in various forums, and that will actually support you framing arguments for your moot court competition. Next is this paragraph, which you can read on your own. I will not dwell deep into this. However, I'll just delve into this particular line, that GPP would be unable to bear the damage caused even by small concussions, right? So therefore, as I said before, please do read up upon the concept of absolute liability or strict liability, and the legal effect of having a dangerous thing in your possession which is likely to spill over, right? That you will find more deeply in the strict liability and absolute liability. Also, there is a concept of imminent threat, that there was imminent threat that the nuclear reactor will break and obviously kill millions of people in my country, whereas that is the fault of this person, right? And the third is that obviously you can also compare with section 81 of the IPC, that is Indian Penal Code, which state that whenever there is a bigger harm which may be committed, so you can do, it is legal actually to commit a smaller harm to prevent the larger harm, and then you can compare it with section 81 of IPC and even the case laws assigned to it. Why I am referencing to various Indian things or practical things, because the judges will understand that, right? So you can't give an argument on, it's better to give realistic examples which the judges will understand and relate with instead of some obscure judgment. So therefore try to focus on real life examples and Indian laws as well, because obviously your judges will know Indian law and not any other law. Next, so this is whatever I have highlighted in this line as yellow is a very neutral fact only, and then obviously it may not be used by any person in his or her favor. This whole paragraph, uh, reading out the message in telecast to widespread hate crimes. So this obviously the respondent can use in his favor. So I'm just ending this video at this juncture, and in further videos I will discuss into the following and foregoing paragraphs of this Moot Court proposition. Please keep liking, sharing, subscribing these videos, because this is meant to act as an equalizer for all law students and for the welfare of everyone. Thank you.